Today with me are the co-chair of the IGO-INGO Access to Curative Rights Protection Mechanism Policy Development Process Working Group in the GNSO. They're Philip Corwin and Peter Rindforth. Welcome.
Good morning.
Morning. So Phil, we heard the PDP working group is wrapping up its work and will publish its final report very soon. Can you give us a preview of some of the proposed final recommendations?
Yes, I can. And we're delighted that after more than 3 years of work, which included a year of obtaining outside expert legal advice, that we're close to the finish line here. We expect to deliver our report before Christmas. The final report's not going to change that much from the initial report. Early on in our work, our original charter asked us to look at both international intergovernmental organizations and non-governmental. We decided early on there was no sound reason to treat non-governmental organizations separate from other private parties. We got permission from GNSO Council to narrow our charter in that respect. That will remain. We are continuing to recommend that IGOs which are worried about their exposure to judicial process can file these actions through agents, assignees, or licensees to give themselves a layer of insulation. One change that we do have from the initial report, initially we had recommended that IGOs which invoke their rights under Article 6 tier of the Paris Convention, which gives them not trademark rights but protection in national trademark law regimes, would automatically get standing to bring these UDRP and URS actions. Now we're saying that should just be evidence to be considered by the panelists as to whether they have standing if they lack registered trademark rights. And the one new thing, while we haven't gone the way the IGOs and the GAC have asked, which was if either party in the UDRP is unhappy with the result, can appeal to a court of mutual jurisdiction, we are saying that if the registrant who loses a UDRP appeals to the court and the IGO then goes before the court and successfully argues that it has immunity in that nation from judicial process, that there should then be an arbitration process available for both parties to settle their differences under that national law. So that comes closer to the GAC recommendation in wanting arbitration, but it still preserve the initial right to go to court, and we let the court, not ICANN, decide the judicial immunity question. So that's pretty much the main points in our final report, and we expect by the end of November to take a consensus call on all of this among all the working group members and to publish the final report before the end of the year.
Great. Thank you very much for that preview.
You're very welcome.
Phil. So Peter, so as Phil mentioned, the curative rights issues of high interest to other stakeholders in ICANN, especially the Governmental Advisory Committee. So besides the point he mentioned, how does this PDP address the policy concerns raised by the GAC?
Well, it's obvious for the name of the working group that we have two specific groups of interests, IGOs and INGOs. And taking INGOs first, we're lucky to have representatives in the working group that have dealt with legal issues representing INGOs, so we could come to a rather quick conclusion on that topic. When it comes to IGOs, we had some old comments, general comments from GAC and from IGOs on what they expected from a working group. But we have actively from the start wanted to have also a discussion during the work with representatives from IGOs and from GAC. And in an early stage, we actually had two informal meetings with representatives where we discussed the topic and how to proceed and work together. Unfortunately, there were no upcoming meetings on that respect, so we have invited a couple of times representatives from IGOs to present the topic for a working group and to have a Q&A discussion on those meetings. to better understand the topic. And we have also had informal conversations with IGO representatives to get as much new input as possible for our suggestions. So I think we have, before we went out with our first public comment period, we had a very good input and knowledge on what was needed. And then, of course, counting on the comment period, public comment period, most of the replies were from representatives from IGOs, and we have spent a number of the follow-up meetings going through in details these comments and to make conclusions on what was needed to give the best input and solution.
Thank you very much, Petter. So thank you for sharing the information, both Phil and Petter. Good luck with the remaining work and look forward to reading the final report.
Yes. Thank you very much.
Thank you.
Thank you.